Dear colleagues, we are starting our next press briefing. As many of you know from the news, on the 1st of October, the Cabinet of Ministers has removed Mr. Musiy, the Minister for Public Health, from his duties. He does not agree, and he is appealing against this decision in court. We'll talk to Mr. Musiy and also with his lawyers. The topic is consideration of the legal claim filed by Ukrainian Health Minister Oleg Musiy after the Cabinet of Ministers as an indicator of independence of Ukraine's law system. So the floor is given to Oleg Musiy, Oleg Spizhenko, who's a lawyer and the president of International Lawyer Council, and Oleg Osadchyi, who's a lawyer from the International Lawyers Council. Good afternoon, dear journalists, dear representatives of other, and I see representatives of public organizations here. This press briefing was stimulated, as far as I and my colleagues, lawyers, are concerned. The reason for this press briefing is that at the request of Maidan, where I was an active participant, and one of the major demands was the rule of law and the establishment of just court system in Ukraine, and that any official in our state has to adhere to the current legislation and respectively does not have the right in the future to act against the law. You know that on the 1st of October, the Cabinet of Ministers of Ukraine, in a very unexpected way for me as a Minister for Public Health, has passed a unique decision on the initiative of the Prime Minister, Mr. Yatsenyuk. You could see this when he was addressing journalists who were attending the session of the Cabinet of Ministers. He said that the government will consider the state the issue of the unsatisfactory work of the Ministry for Public Health and how the Cabinet of Ministers can influence the ministry, including the minister, as far as the improvement of the work is concerned. So it was then that Mr. Yatsenyuk said that he suggests that the Minister for Public Health is removed from his office and to dismiss the first Deputy Minister, Ruslan Salutin. Literally 2 minutes after the journalist left the Cabinet of Ministers sitting, the consideration of this issue takes place out of the agenda, out of the order, procedure, and Mr. Yatsenyuk repeats his decision, and without giving the floor to me or any minister in order to comment in any way on his decision, he just puts to vote just one issue on the removal from duties of Mr. Musiy. And then the ministers vote. 5 ministers vote in favor of this decision, answering the question and understanding that he has to save the situation somehow. And you know that the quorum of ministers is 11 because we have 20 ministers in the government. And then he asks who is against. No one votes against. And then 3 ministers abstain. Other ministers have not taken part in this farce titled a passing of something. 2 days after Mr. Yatsenyuk said that the decision is taken, there appear 3 documents. The first document is the instruction of the Cabinet of Ministers about the removal from authority of ministers. This is a very interesting formula. which I and lawyers maybe will dwell upon. Another document is about the appointment of the acting minister, Mr. Lazarishinets, and the third instruction, which also pertains to this procedure. However, all the documents, according to the procedure of the Cabinet of Ministers, have to be given to ministers before this, and the drafts have to be signed by the Minister of Health or the Minister of the Cabinet of Ministers, by the subject. And there has to be an explanatory note why the documents are being submitted. I state that Mr. Yatsenyuk has falsified the instructions by signing them, because you can take the minutes of the procedure, and there was the voting on just one document that does not exist, and this is a brutal violation of the procedure of the sittings of the Cabinet of Ministers. Coming back to what has happened later, as far as procedure is concerned, 2 days before this sitting on the 3rd of October, on the 1st, before the 1st of October, on the 29th of September, I, as a law-abiding citizen, according to the law on the election of MPs, I have submitted personally to Mr. Yatsenyuk the application that I have to take a leave, as I was registered on the 24th of September as a candidate for an MP, and I don't want to use administrative resource not to influence the voters and to honestly conduct my pre-election campaign. For 3 days, the Prime Minister has ignored my statement, and there's an interesting U-turn in the form of this instruction. How I think the Cabinet of Ministers has done at the initiative of the Prime Minister, who is, of course, the initiator of this instruction, I will probably dwell upon in detail when there will be questions. If you raise the questions about attitudes and relations in the government, about the ignoring of thoughts of the ministers and the usurpation of authority by the Prime Minister. But today we're talking about this 877R instruction about my removal from office. I addressed the International Lawyers Council, requesting them to legally file the claim to the Court of Appeal, which was done on the 3rd of October. And if Ukraine is going to the European Union, and we are in favor of the rule of law, and the state officials have to behave respectively, we have to act according to the norms of current legislation. To the current legislation, the Constitution or the law on the Cabinet of Ministers do not provide for the procedure of the removal of the minister. There's even no term about this, legal term. On the other hand, the Cabinet of Ministers law says that the minister is a political figure and carries only political responsibility, and any actions with the minister, both appointment and dismissal, are within the competence of this Parliament of Ukraine. Instead, the Prime Minister has usurped the power and taken the functions of the council of the Parliament upon himself, declares that he is a European premier, but in reality, adhering to the Eastern values of dictatorship, he allows himself to issue illegal, unlawful instructions. So, after we appealed to the court, they designated that they will be in sitting on the 16th of October. Even before that, I asked to satisfy my claim. The lawyers will tell you what this is. And we need this to suspend illegal decisions. I understand as a law-abiding citizen that after an unlawful decision and after by law, I had to appoint the acting minister, but the cabinet of ministers took this upon themselves, and this can have some legal consequences for the ministry and the entire system of health protection. You know, the orders which are signed by illegally appointed person. There were other appointments like deputy ministers and heads of departments. There was a strange procedure when the acting minister, who was deputy minister, he submits to himself the document about dismissal, then he submits to himself the document on the appointment of acting minister, and maybe not even in European, but in Asian countries you don't see such a strange approach to the appointment of officials. But this is a great danger, of course, because during this month, while I've been removed from the office, the passing of legal decisions and the issuing of orders that can lead the system of health protection to collapse. So the decision of the court on the 16th of October was about the strange wording in the court decision that the court is not yet ready to pass legal decisions in this matter because there's a pre-election campaign and they are, they do not want to be in the political range of the Ukrainian society, so they reappointed the sitting to the 29th of October. So on the 9th of October, 29th of October, they hold another hearing at the Ministry for Public Health. Their legal service addresses the court with understanding that the managers of the ministry are now in unlawful position and there can be grave legal consequences for their activities, so they want them to join as a side as a party in the court hearing. So the court gives them 2 weeks for legal examination of the documents, how the ministry will further take part in court hearings. So the next court hearing is designated for the 11th of November. I believe sincerely that the court system can have a unique chance to show that if a prime minister or any state official adopts an unlawful decision, they have to bear full responsibility for this, and such decisions by the prime minister or the president or anyone, how it happens in Europe, should be cancelled by a court, and the court has to purify themselves and to go through inner lustration that was demanded by Maidan.
Okay, let's listen to experts, lawyers, about what is this procedure. According to the legislation of Ukraine, there's no such a thing as removing a person from executing the duties of the minister. The lawyers myself and some other lawyers were involved, other lawyers, because that's the first appeal, the first claim in the history of Ukrainian legislation. And you remember, we are dealing with the People's Minister, because you remember that the People's Assembly basically entrusted to this person this position of the minister, and the people in the face of the representatives of the Verkhovna Rada voted for the trust to the minister. in this case, having read the text of such instruction, you can come to a conclusion, to one single conclusion, that this instruction has to be cancelled. Why it has to be cancelled? Because, in fact, within 20 years of independence, both the lawyers and the judges, they are tired of living in the state where at such a high level the regulatory acts are ignored. We have analyzed all the legislation of Ukraine for all these times, and we made conclusion that there are certain procedures of removing the person from executing the duties, but these procedures are within the criminal process. They are in relation to civil servants, to those who work according to the labor contract, but we know about the cabinet of ministers that the member of the government, like a minister, is a political position and is not covered by labor legislation or the legislation on civil service. And such position as minister cannot be removed from executing the duties, and it cannot have such wording in the text of the instruction. So first thing we did an analysis, and frankly speaking, neither lawyers the lawyers could not believe that the highest executive official can make such a simple mistake, issue such instruction. Many lawyers were involved, and they were thinking about how to comment such instructions. And then we came to conclusion that such a instruction should be cancelled. After that, we filed the claim. If we had any doubts that such instruction could be enforced, then we would have been looking for some compromise. But when at such a high level, the member of the government signs instruction which is illegal, then having two revolutions behind us and having this unified position of the lawyers, and this unified position is to issue the claim. So then legally, the court should pass a resolution about who's right and who is not, and whether laws work in Ukraine. And when we learned about the name of the judge, same day we issued the claim about the appeal to suspend this instruction, and that was done not to allow in the future the illegal effect of this instruction, because that leads to new and new problems for the ministry, for all the legislative documents which will be signed by the acting minister, to make impossible all problems that the new minister may have, the minister that will be appointed after the elections. And during this process, the lawyers of the Ministry of Justice and the claimant's representatives were talking, and we were thinking about how to legislatively prove that. And our objective was that neither the criminal code of Ukraine nor the labor code nor the legislation on civil service have the procedure of such removal from the execution of duties the minister. And that was mentioned by the judge, and that's a heroic deed of the judge, because having such a paragraph in the text of the resolution of the court, the judge shows to all the parties of the process that when the case is considered, then basically there will be the resolution already. A month or 2 months We lacked basically for the judge to pass such a resolution, because that would make impossible all other resolutions of the acting officials of the minister. We knew before this resolution was issued that the minister takes vacations because of the election campaign, and the minister has resolved that conflict. He went to vacation. What was the objective when signing this resolution? We do not know, because this resolution is the resolution which will be cancelled judicially. If on the 16th of October the court would have passed such a resolution, then we wouldn't be here, and we would be happy that in Ukraine we have, that Ukraine is on the way to Europe, that the law, we will have the rule of law, that the court is independent, but little time passed from the day of revolution, and that is why our objective is that on the 12th of November, not to ruin the trust of the citizens of Ukraine, and not to so that people should believe that the court is independent branch which can pass fair resolutions, and irrespective of who you are appealing against, whether that's a civil servant or a common person, but you can find defense in the Ukrainian court. Now this doesn't happen. If on the 16th we politically could understand why the judge does not pass such a resolution, because that might ruin the image of someone, but we believe that if the court had passed such a resolution and the lawyers of the Ministry of Justice would have supported it, then we would all be able to see that the government respects the law. But this is not the case, unfortunately, and we believe that this is the first claim in the history of Ukraine when there is a mistake and it has to be corrected, and the judge should be courageous enough, and the head of the government should be courageous enough and correct the mistake. And that's the normal way to improve the system and the judiciary of Ukraine. And let us listen to Mr. Osadchyi, also the lawyer of the International Council of Lawyers. First of all, I would like to mention that today the judiciary cannot pass legal decisions, because our law courts are so biased that if they follow it is very difficult for them to observe the legislation, observe laws. And also in this case, there was an interesting thing. There were debates between the representatives of the Ministry of Justice and representatives of Oleg Musiy. The representative of the Ministry of Justice stated, but the Cabinet of Ministers has the right to pass resolutions or instructions. Yes, it has the right to pass instructions, but according to our legislation, our legislation does not provide for removal from exercising duties. There's a dismissal, and only the Verkhovna Rada can dismiss the member of the Cabinet of Ministers, because the Verkhovna Rada is appointing such a person. And we stated that once we are creating the legal state, if we are creating independent judiciary, then the judges would have to be independent in passing resolutions. But we have a resolution, and that confirms the fact that unfortunately our judiciary has not reached the position when they can use or apply the regulations. Any questions? Maybe I would add, I would like to address, I understand that the International Lawyers Council
and the lawyers of Ukraine who work there are highly qualified, but we have a lot of other lawyers and lawyers associations, and I want to address them to join this work at the level of probably holding a conference, all Ukrainian lawyers conference, in order to show the absurdity of what's happening or what can happen in the executive branch of Ukraine's power, that of course the cabinet of ministers can issue any instructions, but they have to be lawful. They cannot issue unlawful instructions, and I think that raising this issue to the public level about the unlawfulness and the cancellation of unlawful instruction could be a precedent to purify the good name of court and lawyer system, could be a positive precedent and a lesson for those officials who think that they can do anything in Ukraine while they hold high official positions. And so probably independently on how the court will regard this issue, the initiative of a broad public discussion of government decisions can be there and can have a international echo, because some officials who want to again be a prime minister or hold high positions, well, the public has to influence them in a more serious way so that Ukraine does not have to make another revolution. My question goes both to Mr. Musiy and the lawyers. Do you plan to come back to the position of the Minister of Health, or do you want to work in the parliament? And the lawyers, could you please tell us, you said that there can be doubts about the decisions of the current managers of the Ministry of Health. Does this consider the tenders that they are holding? As far as my coming back is concerned, that some mass media said that Musiy is appealing in order to come back. I don't have these plans. I am a legally elected people's deputy in a one-man constituency, and I have some moral obligations for my voters who voted for me, 30,000 people. I understand that it is impossible to work honestly in the government that is headed by Mr. Yatsenyuk, and it is impossible to protect the ideals of Maidan. So I see my work in the parliament. This means that I will work in the parliament, sooner of all in the Committee for Health Protection, and will be implemented the program of the health reform, which is already with Mr. Yatsenyuk for 3 months. And he tells us that one of the reasons I've been removed is the lack of the draft reform, but it exists, and I'll try to implement it through the legislature rather than through the executive. So this claim is the precedent, and it has to be exhausted, not because of my comeback, because I don't have such aim. As far as there are doubts about the legality of the state purchases, this issue was raised in the court, and we asked the court to stop such instructions because there's And of course, how can you transfer the authority with such a terminology and such decision? There's no legal formula for this. This is why on the first day when we got to know about this act, the claim was to protect the interests of the Ministry of Health, and this was proclaimed by the lawyers of the Ministry of Justice and the lawyers of the defendant in order for Mr. Minister could come back to his office for one day and to legally issue an order to transfer his authority to his deputies, and then he leaves for his legal leave. There's no aim to make him come back to the office. This was a request of the defending lawyers to avert some possible negative consequences that can take place because this instruction is cancelled, and this will be cancelled if the court adheres to the letter of the law, because there's no such clause in the legislation, and there's no procedure of transferring the authority of the minister. For instance, there could be an application for his leave and the transfer of his authority to other people, but on the 11th of November we will decide this issue with the court, because this is a topical problem, very topical. We'll solve this in legal order. It depends also on how the court decision will be written down. If the judge says that it was illegal from the moment of its formulation, that's one thing. Then if they write that from the moment of adoption of the decision, you know, this claim is the first in the history of our court system. So Mr. Minister says rightly that you have to invite ministers and judges and think what's going to happen to the ministry when such a decision is passed. And the problem is rather serious. I have a question to Mr. Spizhenko. If the court decides not in favor of Mr. Minister, what are you going to do? Legally and from Mr. Minister, the procedure is very clearly laid down in the code. This is appeal and then cassation and then the European Court. Yes, until the end is put to irresponsibility for such unlawful actions, until the letter of the law is adhered to in this country, not a single lawyer, not a single judge could sleep calmly. If they pass such a decision, then they have to think what's going to happen to lower levels, what's going to happen on the level of regions and districts. This is an essential problem. Mr. Minister, the decision of the Cabinet of Ministers, is it caused by the fact that the Parliament could not vote for your dismissal and the Prime Minister could not dismiss you in a legal way? I think yes, and I regard this in a political aspect. This is a political order from Mr. Yatsenyuk and his political force. This is the punishment of Maidan, and right 1 month after we representatives of Maidan were appointed, there were constant reproaches. What's about the appointment of Maidan? And you don't have experience, and the government was systematically pushing the the Maidan representatives, and Mr. Sheremetov was the first person who went away, who left calmly. This is now Mr. Yatsenyuk and the president are again quota appointments, but he methodically over 7 months was imposing those quota appointments to every minister. Sheremetov was a minister who did not agree, and he was working alone in a huge ministry where there were 1,300 officials. He had only one deputy. He was not. He did not agree with new controllers who became very close to the current prime minister, quota appointments of people who perform political orders from their political bosses. When I 20 times on the side of the ministry every 3 days I was telling him, start the public procurement procedure immediately. And he was looking at me and saying, well, I ignore your instruction. You didn't appoint me. My political forces and bosses have appointed me, so I don't give a S about you. So 20 instructions from the minister to the deputy, and the deputy does not fulfill any of those. This is nonsense. After this, I have twice asked the prime minister to dismiss the first deputy who was appointed according to his political quota. And for 3 months, my request is with the prime minister. He does not react, but when it is beneficial for him politically, on the 1st of October, he shows this request and he instructs to dismiss the first deputy Salutin because the minister requested so. This is manipulation and usurpation of power by the prime minister. Whoever the prime minister is, Mr. Yatsenyuk or someone else, this has to be a precedent of solving this issue. And I, being now a member of the legislature, will initiate one of the first laws, urgent changes to the law of the cabinet of ministers, because the prime minister should not usurp the power and do whatever they want with the country.
Could you please tell? I have a very simple question. Mr. Musiy will be the member of parliament, and you will have in your labor book the member of parliament of Ukraine, the previous job, Minister of Health. And what will be the reason of dismissal? What will they write there? Dismissed, tone, desire. Will you ask a judge? What will they put into your labor book? First of all, I want the journalists to understand. I declare it everywhere. I go to work to the Ministry of Health. I am an acting Minister of Health, and it says to remove from powers according to the position. So it looks like I have a position, but I don't have any powers according to this resolution of the prime minister. It's like an English queen. That's probably the first case in Ukraine when there is a minister but without powers. Legally, I cannot sign orders and cannot issue any resolutions, even though I am an acting Minister of Health. And one more question. The hand of the government has been accusing you in non-professionalism, and he was trying to remove you from your position. You being the MP and knowing about what are the forces in the new parliament, do you believe that you will be more efficient as a legislator but not as the representative of executive power? Yes, more efficient, because every MP is the subject of legislative initiative. I will have the right to submit any pieces of legislation and signed by me, because those who work in for those who work in the government, the cabinet of ministers is the initiator of the laws. When, for example, we were drafting some pieces of legislation or regulation, you know that there was this vaccine against TB, and the Verkhovna Rada unblocked now this procedure. I was basically drafting this regulation 5 months ago, and it took 5 months for it to get to the Cabinet of Ministers. And also talking about the reform, the new system of health, I am the ideology. That's my idea, and this is a concept, a document. And when I was the Minister of Health with powers, I submitted it to the governmental committee. That was to be considered by the governmental committee. According to it, it has 5 substantial draft laws which are to be passed by the Verkhovna Rada, like the law on mandatory social medical insurance, law on the self-government of doctors, amendments to the law on public health, maybe the medical code in the future, the law on medications. And the law on medications we were drafting for 5 months in the Ministry of Health, and it hasn't been submitted for consideration. I believe that the people who want to change the system, I am insisting on changing the system, but not just on closing the gaps, filling in the gaps, but the legislative power will be efficient, and those young people who are not engaged into old corrupt schemes, not engaged into old ties, will get united in the new parliament and will show a new quality of the parliament at the legislative level. And I will do everything I can to help them, being the member of parliament. So we'll be looking forward for the sitting of the court on the 11th of November, and we'll be happy to see you here as a legislator. And this hearing is an open hearing. Please come. We invite you at 9 o'clock in the morning on the 11th of November. This is the public open hearing. Our next press briefing of the Deputy Head of Presidential Administration, Mr. Shimki,